Good afternoon, everyone. We have a very informative program scheduled for today. I'm going to take a few minutes now to go over the agenda so that everyone knows what we will cover. In a few moments, I'll turn the program over to one of my colleagues in our New York City office, John Sweeney. John has a tremendous amount of experience handling workers' compensation matters, and he will be discussing the recent legislation regarding workers' compensation claims for mental injury. Next, we will have Alyssa Christian from our Syracuse office. Alyssa has presented on the webinar numerous times recently, and I'm sure is familiar to many of you. She will be providing us with another update today on the Corporate Transparency Act. And last but certainly not least, Jeremy Scher is with us from our Rochester office. Jeremy will be covering a recent decision from the Second Circuit, which upheld the elimination of the religious exemption to school vaccination requirements. Okay, now I will turn it over to John.
Good afternoon, everybody. Kathy, could we start with the opening slide? So here today I'm going to talk briefly about the new mental injury legislation in the workers' compensation. And it's been something of a comic opera over the last 3 or 4 months, because the legislature has gone back and forth and enacted something that undid the same thing. So let me give you a little background about workers' compensation and mental injury. Mental injuries have always been compensable under the workers' compensation law if they stemmed from a physical injury. But in times past, an injury that was solely mental was not deemed to be compensable. It wasn't until about 50 years ago when the New York Court of Appeals issued a decision that said that certain mental injuries could be compensable in the absence of physical injury. And that case stemmed from a scenario where a secretary got a call from her boss in the adjoining office. And the boss said, "Call the police." The secretary then enters the boss's office and finds him that he shot himself in his head. So the Court of Appeals said that that was a kind of event that could generate a compensable mental injury even without some physical injury. Basically, it created a rule that said for mental injury to be compensable all by itself, it had to stem from something rather extraordinary. Next slide, please. Several years ago, the legislature modified the requirement for certain employees. It changed the rule for first responders, that were firefighters, police officers, and emergency medical technicians. The new law made mental injuries compensable even without assuring there's some extraordinary event. And the reason for this was these type of people see things like death and horrible accidents every single day. So to require something to be extraordinary was almost meaningless. So it made some sense to create a new standard for just this small group of people. However, recently something else happened. Next slide, please, Kathy. Last December, the governor signed legislation which applied that first responder rule to all employees, and that basically eliminated the need for a showing of some extraordinary work event. So somebody could point to some trivial slight at work and claim they had a mental injury. Now that took effect on January 1st of this year, but shortly after that, the legislature had second thoughts. Next slide, please. Just to confuse everyone, in February, the legislature enacted a new amendment that modified the prior amendment, and it superseded it and rendered it effective. And the new amendment added some requirements regarding medical evidence and articulated a more precise standard for mental injuries. But primarily what it did was it repealed that standard that was enacted on January 1st. Next slide, please. So the legislature enacted a new standard and requiring a more strict showing for mental injuries. And I'll just read you a part of what it added. It said, if you're claiming a mental injury, it said a person must demonstrate that such disorder was out of extraordinary work-related stress attributable to distinct work-related events directly related to employment and occurring during the performance of the employee's job. This is pretty specific about ordinary, everyday trials and tribulations are probably not going to be enough under this standard. However, there's a wrinkle to this. Next slide, please. This basically returns to the original standard that was in effect up until January. Arguably, even makes it harder to make a claim for mental injury. Your employee is going to have to point to something extraordinary during work activity to sustain a claim for a mental injury. Next slide, please. So the new law actually does not take effect until June, which is kind of bizarre. But because the January 1st amendment was repealed and it's no longer in effect, we are now operating under the law, the prior law that was in effect for the last 50 years. That is, a mental injury requires some showing of an extraordinary event. Now, why the legislature did this, and why they had second thoughts and did what they did, is anybody's guess. It's almost embarrassing to see how they flip-flopped here. But the bottom line is, as of today, we're operating under the same law we've been operating under for the last 50 years. And that is, if someone is claiming a mental injury, they need to point to something extraordinary at work that caused the mental injury. Without that, they probably will not be able to sustain a claim for a compensable mental injury. Next slide, please. Although confusing, none of this should affect the way an employer handles and processes the claim. If you receive a claim for mental injury, submit it to your insurer or administrator, and they will sort things out. You do not have to treat claims any differently than you have in the past. This is kind of, as I said, it's an amusing comic opera of our legislation in action. But as it stands now, nothing has changed with respect to the mental requirements for mental injury. So if if you have any questions, feel free to reach out to me at jsweeney@bsk.com. I'm happy to discuss it with you. Thank you all.
Thank you, John. Yeah, this is a very interesting topic that's been discussed a lot recently. As John noted, the important thing for employers to keep in mind here is that the changes in the legislation should not impact the way that they handle workers' compensation claims. So if you receive a claim related to mental injury, do what you've always done and submit it to your insurer or administrator, as John said. Okay, so moving on, we have Alyssa Christian to update us on the Corporate Transparency Act. Alyssa, we're delighted to have you back. The floor is yours.
Hi, everyone. As Carrie said, I'm here to give you the latest update on the Corporate Transparency Act. This time, the news is a little different. I do not have an update on the court cases that have caused the back and forth that you've probably grown accustomed to hearing me speak about. Instead, the federal government made two big announcements in the last few weeks regarding the enforcement and the future of the Corporate Transparency Act. I have these two announcements outlined on the next slide. So the first announcement came from the Financial Crimes Enforcement Network, which is the division of the Department of Treasury that is implementing and enforcing the Corporate Transparency Act. And in late February, it announced that it would not be imposing any fines or penalties on companies who did not comply with the March 21st deadline to file your BOI reports, which is what I had reported on the last time I was on this webinar. That announcement also hinted that there would be a new rule coming out to help reduce the regulatory burden on small businesses, but also prioritizing the companies that pose the biggest risk for national security. A few days later, the Treasury Department then came out with an announcement that was a little bigger, in my opinion, because it said that it intends to have that new rule really limit the scope of the CTA to only foreign reporting companies. And so on the next slide, I have a few points on what this means going forward. So as of right now, it really isn't necessary to file any BOI reports. As I mentioned, that March 21st deadline is technically still in place because those were just announcements of their intention to change the rule. However, since there will be no penalties and there's this new rule coming out, there really is no requirement to actually file. With the announcement from the Treasury, I know there's a lot of questions regarding what will this mean for companies that are either that have some kind of foreign operation or have ownership or management structures that involve foreign corporations or people from other countries, what that will mean. Based on the announcement, it looks like it's only going to apply to foreign companies that are registered to do business in the United States. However, until that rule is actually proposed and announced, we can really only speculate on what that would mean. So if there is a potential that your entities may have some kind of foreign reporting requirement, it's important to stay up to date on what the Corporate Transparency Act will look like going forward. I'm sure once that rule is announced, I will be back to explain that. But for the US reporting companies, as of right now, the federal government has signaled and straight up announced that the Corporate Transparency Act filing requirements will not be applying. One more thing I'd like to point out, though, on the next slide is the New York Limited Liability Company Transparency Act. This is a law that it's obviously a state level law. It only applies to limited liability companies. It incorporates much of the CTA in the statute itself. So similar to the CTA, it's a disclosure law where New York is asking entities to please disclose who are its owners, who are its managers, and other information like that. It's supposed to go into effect on January 1st, and similar to the CTA, it gives a year for compliance. This date has been pushed around a bit, so with these changes to the CTA, it's unclear whether that's going to be pushed again. I also want to point out that because it incorporates many of the definitions from the CTA, it's unclear whether they will need to change or do anything with the New York Limited Liability Company Transparency Act. So I really just bring this up to let you know that although US companies do not have to comply with the Corporate Transparency Act anymore, there may be state level reporting requirements in the near future. To give you a little update on the court cases that have gone back and forth, they are still ongoing. The constitutionality of the CTA is still being, weighed by the different circuit courts. We haven't had any updates on those yet. However, it seems that with the new rule being announced, those decisions might not carry as much weight as we previously thought they would. But again, I will be keeping my eye out for what that means for when those come out and what that means for all of the US reporting companies. So as always, stay tuned. We'll have more client alerts out if there's anything changing. And again, a new rule will be coming out probably very soon regarding limiting the scope, and I will likely be back to report on that. If you have any questions, please reach out.
Thanks, Alyssa. We appreciate the update as always. I will now turn things over to Jeremy Scher, who will discuss the recent Second Circuit decision with us. Jeremy?
Thanks, Carrie. I'm Jeremy Schur. I'm a member in the Rochester office. I use he, him pronouns. So on March 3rd, the Second Circuit issued a decision called Miller v. McDonald, which I'll put in the chat. And Miller upheld a decision out of the Western District from Chief Judge Wolford that dismissed a lawsuit, and that lawsuit in turn had challenged, this is a mouthful, it challenged New York's repeal of its religious exemption to school vaccination mandates as unconstitutional. So to take a step back and summarize all this, in 2018 and 2019, there were major outbreaks of measles throughout the country, and New York was, as the Second Circuit put it, the epicenter. The legislature proceeded to end or repeal a previously existing exemption to the rule that all children attending school must be fully vaccinated against various diseases, including measles, and that exemption was based on sincerely held religious beliefs. So that exemption went through in 2019. So a group of Amish community schools sued the Department of Health and the Department of Education, alleging that the repeal of the religious exemption, which would effectively require children attending those schools to be vaccinated, violated the children's and their parents' First Amendment free exercise rights and their substantive due process rights under the 14th Amendment. Now, this case actually follows a very similar Second Circuit case that was handed down in 2023 called We the Patriots, USA, which sued Connecticut for its repeal of its own religious exemption to vaccinations, which was instituted for the same reason, due to these measles outbreaks in 2018, 2019. And We the Patriots had dismissed the challenge to the repeal. And when I say dismiss, I mean dismiss at the motion to dismiss stage. The case never made it past the pleadings in We the Patriots. The Second Circuit engaged in a two-step analysis. First, it considered whether there was a valid or a viable free exercise claim stated based on the repeal of the religious exemption, and concluded no. And then it considered whether there was some sort of due process claim that could be brought under the 14th Amendment based on the rights of parents to control the upbringing of their children. And the Second Circuit said no as well, and affirmed dismissal of the We the Patriots case. So then fast forward to last week, and this very similar case comes up through the Western District of New York to the Second Circuit, Miller, making the same allegations that the New York repeal of its religious exemption is unconstitutional. The real difference between the two cases is that the plaintiffs, again in Miller, were board members of Amish community schools. And there is a tradition of Amish children essentially not being vaccinated and also not being required to attend school if it, not being required to attend school, period. There can be no mandatory public education for Amish children, and that goes back to the 1972 case of Wisconsin v. Yoder. And that's not special treatment for Amish children. That's basically the rule everywhere. You cannot force children to go to public school. States need to give a homeschooling or private school alternative. So the plaintiffs in the Miller case argued that Wisconsin v. Yoder created binding precedent that basically exempted Amish children from the vaccination repeal, and the Second Circuit disagreed, affirming Judge Wolford dismissed the case, performing the same analysis as in We the Patriots, finding that there was no free exercise claim stated and that there was no due process claim stated. We have seen in the Rochester office a number of unrelated lawsuits to try to get, unrelated to this particular case, Miller, but related in theme, a number of lawsuits to try to force schools to admit children that have not been vaccinated. And the ones that we've dealt with have all failed. The schools have successfully resisted attempts to get courts to force them to admit unvaccinated children, as the public health law in New York is quite clear that schools have no discretion in this regard. If children do not meet statutory vaccination requirements, schools cannot admit them and lack discretion to do so. So I think it's a safe assumption that we're going to see more of these cases, to try to find ways to require schools to admit unvaccinated children. Interestingly, in the Miller case, a coalition of 19 or 20 states, led by Alabama, submitted an amicus brief in support of the Amish school, saying that there should be a constitutional right to exempt children from vaccination requirements on religious grounds. So this is an area where we expect ongoing debate and may make it up to the Supreme Court.
Thank you, Jeremy. We appreciate the update and your insight into this issue. And thank you everyone for tuning into the webinar today. I don't see any questions in the Q&A, but we're glad that you joined us. We have the contact information for all of today's presenters on this slide. Please feel free to contact any of today's presenters or myself with any questions. I won't be with you next week as host, but I will be back on March 25th. I look forward to seeing you all then. If you're available, please tune into the webinar next week, as Gabe will be hosting. Thanks again, everyone. Have a great rest of your day.